be talking about the new updates that TREC has recently put together for our contracts, our addendas, and we do have a new form out there. And so these forms are available for for voluntary usage starting on December 16th, and mandatory usage will begin January the 3rd. So I did check, and they are currently on the Texas Realtor site, as well as they should be populating into your form vendors that you have. You should have them available to use December 16th, 2024. So let's see what has changed with the forms. So this is taken directly from the TREC website, and let me just take a few minutes to explain to you guys and make sure that you understand the difference between TREC and Texas Realtors. And I know for most of you, you're going to say you already know this, but it is important for me to go ahead and say. So TREC is our licensing entity. Texas Real Estate Commission is our people who license us. It's a government entity, whereas Texas Realtors is a trade association who supports us and who we can go to. And both of them have forms and addendas out there where TREC is promulgated, required by law. Texas Realtors are forms that are out there to help us for us to be able to utilize. So two separate entities. Texas Realtors has been able to move a little quicker than our government entity, just like any other government entity or government situation that needs to take place. There are timelines in place that have to happen. And so that's why TREC is just now getting the promulgated forms ready for us to utilize. So the ones that that have been changed, you will see here is the unimproved property contract, the 1 to 4 family residential contract, the resale, the new home contract, incomplete construction, the new home contract, complete construction, the condominium resale certificate, addendum for section 1031 exchange. That is a new form that we will just briefly look at. The third-party financing addendum, amendment to the contract, residential condominium contract resale, farm and ranch contract, and then the addendum for the backup contract has also had some significant changes. Now, we're not going to go into each of one of these because what has changed in most of them is what we're going to address in the 1 to 4 contract. So that what is in the 1 to 4 contract goes into the majority of the other contracts, such as the new home contract, complete and incomplete, as well as the farm and ranch. And what we're changing, or excuse me, what has been changed, not what I'm changing, but what has been changed is in relationship to the compensation and what it looks like on the 1 to 4 and the subsequent contracts that we do utilize. So let's head into them and see what it looks like. So the first one we're going to talk about is the 1 to 4 family residential contract resale. And I've taken some excerpts out of TREC, being that it is the government entity, Texas Real Estate Commission, and they are telling us exactly why they have made the changes. And so it says paragraph 4 is amended to add the term geothermal to the definition of the natural resource leases because of a 2023 law change that stipulates property owners own the geothermal energy below the surface of their land and can drill or produce that energy and associated resources. So because of the terminology changed due to a law change, we have to change our contract. So you will see in paragraph 4 under C, natural resource leases, the term geothermal has been added. Another change that we're going to be talking about is to be consistent with the recent update from the Texas Department of Insurance procedural rule, paragraph 6C1 is amended to include the option of providing the T47.1 declaration, which does not need to be notarized in lieu of the T47 affidavit, which needs to be notarized when the seller furnishes the buyer an existing survey. So in lieu of providing a no survey requirement option, Paragraph 6C2 is amended to read, buyer may obtain a new survey instead of buyer shall obtain a new survey. So just a word change, but that word change is very significant. Buyer may obtain from buyer shall obtain. And it adds that if a buyer ultimately fails to obtain the survey, the buyer does not have the right to terminate the contract under paragraph 2B on the third-party financing addendum because the survey was not obtained. So it goes back to the buyer to make sure that they are getting what they need for the transaction. So we do have a copy of what that is going to look like. So here is what C looks like. So C1, within so many days after the effective date of this contract, the seller shall furnish to buyer an affidavit or declaration promulgated by the Texas Department of Insurance, the T47 affidavit or the T47.1 declaration, period. Buyer shall obtain a new survey at seller's expense no later than 3 days prior to the closing date. That hasn't changed. If seller fails to furnish within the time prescribed, both the existing survey and affidavit or declaration. So again, very important, listing agents, that your sellers get this information. You need to give them the forms and let them choose which one they want to do. If they want to do the T47 affidavit, remind them it has to be notarized, or they can use the unnotarized T47.1 declaration. Just note, I don't have that form here for us to look at, but you need to make sure that you know what that is. There is a requirement for the seller to put their birth date on there, so they may not want to do that. So if they don't want to do that, then they're going to need to get the affidavit and get the notarized. And then if for some reason they don't, now this hasn't changed, if they don't give the survey and one of the T47 forms, then they will be required to pay for a new survey. If the title company or the buyer's lender does not accept the existing survey or the affidavit or the declaration, then the buyer shall obtain a new survey at someone's expense, the seller or the buyer, and that's negotiable. So make sure you understand that when you're presenting this to your sellers and then also to your buyers. C number 2, within so many days after the effective date of this contract, buyer may, there's that word change, obtain a new survey at buyer's expense. Buyer is deemed to receive the survey on the date of the actual receipt or the date specified in this paragraph, whichever is earlier. New verbiage added, if buyer fails to obtain the survey, buyer may not terminate the contract under paragraph 2B of the third-party financing addendum because the survey was not obtained. Time is of the essence here, remember that. And so buyer's agents, make sure you're staying within the time frame and making sure your buyers are doing what is needed and required of them in the survey situation. Moving right along, there is another change required because of Texas law. It requires a seller to provide a buyer a copy of any mold remediation certificates issued during the 5 years preceding the sale of the property. So the new paragraph 6E11 is added to provide information regarding this requirement, except in the unimproved property contract. Paragraph 6E12 is modified to add specific examples of the types of notices that should be listed in the paragraph and to add a caution that seller's failure to provide required notices may provide buyer with certain remedies like the ability to terminate the contract. So understand what these are. And here's what that's going to look like. 11, there's that certificate of mold. So we have to ask our sellers if they've had any mold remediation. New paragraph, okay? And then 12, there's those required notices, and it's giving those examples: utility, water, drainage, public improvement districts. They've taken out the abbreviations MUD, which we all call MUD, or the WCID or PID. They've removed that because a consumer doesn't understand what that is normally. So we're trying to make it a little easier for them to understand what it is we're asking for. And then it also states seller's failure to provide the applicable statutory notice may provide buyer with remedies or rights to terminate that contract. So again, these are added into the contract, the promulgated contract that exchanges the property from one person to another. So we have to make sure we're protecting our clients, both on either side. So here's the one that I know everybody is really wanting to get to, and this is paragraph 12. So in light of the recent discussion surrounding broker compensation, paragraph 12A, 1A, and 12A2 adds that each party pays the broker fees that each have agreed to pay. Paragraph 12A, 1B is amended to allow for a specific seller contribution to the buyer's brokerage fees. A new paragraph, 12A1C, has been added to separately address other seller contributions. And that was what was previously in 12A1B. We also call this seller concessions. And the prior language that specified the order in which any contribution was to be paid, as well as a limitation on the type of fee that could be paid, has been removed. Conforming changes are also made in the amendment to the contract, so it mimics what paragraph 12 states, and we're going to look at those. All right. So very important that you guys pay attention to this part of it because we've had a lot of confusion on it and it can get very confusing, but we'll walk through it slowly so that you can see exactly what it is stating. So 12A, the following expenses must be paid, at or prior to closing. So A states, seller shall pay the following expenses. Key term, shall pay. Seller's expenses are A, releases of existing liens, including prepayment penalties, any recording fees, release of seller's loan liability, tax statements or certificates, preparation of deed, 1/2 of the escrow fee, brokerage fees that seller has agreed to pay, that's in the listing agreement, and other expenses payable by seller under this contract, semicolon. B states the following amount to be applied to brokerage fees that buyer has agreed to pay. There is going to be a checkbox for a specific amount or checkbox for a percentage amount of the sales price. Check only one of those boxes. Now, what a lot of agents have had some heartburn about is it says the following amount to be applied to a brokerage fees that buyer has agreed to pay. This is no different than the way we've done it before, what we've agreed to in our buyer rep agreement, and we've come and asked the seller now to pay that amount, and that's what this says. So A has that semicolon at the end. Okay, that states, and any other expenses payable by seller under this contract. So B is now a part of the contract, and it's just explaining that the buyer has asked the seller to pay the amount that they have contracted their agent to represent them for. So whatever that is goes there. So I hope that explains that. A addresses the fee that the listing agent or listing broker is going to get paid. B is that buyer's agent compensation. And then C. C is an amount not to exceed an amount to be applied to other buyer's expenses. So this can be the concessions, whether it be for, buy down rates, whether it be for repairs that you are asking for ahead of any other amendments to be done, anything else. What you have to make sure, though, is that the concessions that are here in C are in line with the lender requirement of the cap. So remember that whatever loan product that buyer is utilizing, that the concessions fee cannot be more than a certain amount. And that will depend on the loan product, how much they're putting down. So talk to that lender before you fill out the concessions, because the worst thing to do is to negotiate an amount that goes in here for concessions, and then you have to leave some of that on the table because it's exceeding the amount that the lender requires. And I tell you that because I've done that in the past. So just be aware of that. So 12 really is not that intimidating when we read the whole thing together. So just practice it before you present it and make sure that you're understanding and can answer all those questions. Okay. 12.2 does talk about the buyer shall pay the following expenses. So in other words, if A1 is not filled out at all, so the buyer is not asking the seller to pay the compensation, the buyer is going to be paying that compensation. And that's what it says down at the bottom in this paragraph: broker fees that buyer has agreed to pay. So if they're not asking for a buyer agent compensation or brokerage agent, buyer's broker's compensation, and they're not asking for any concessions, 2 is reminding the buyer what they're going to be paying. They're going to be paying all of these other expenses as well as the brokerage fee that the buyer has agreed to pay in the buyer rep agreement. So it's addressed. The next change is the compensation disclosure in the brokerage information section of the contract, except for the farm and ranch contract, has been modified to remove the parenthetical referencing the MLS and to add checkboxes to allow for the fee to be reflected either as a percentage or a dollar amount. And this is utilized when we know ahead of time if the seller has agreed in the listing agreement to go ahead and pay the other broker's compensation. So for instance, I just had a conversation with a listing agent, and she informed me prior to going and showing the property that her seller is paying a buyer's agent compensation. So I'm not going to have to fill out anything under 12 regarding compensation. I will put it under here for informational purposes only. Pursuant to a previous separate agreement, the listing broker has agreed to pay other broker a fee. Again, a dollar amount or a percentage of the sales price. So that information I just got from that listing agent, I would put here. Check whichever box I need to check, and that will be sufficient. Now, best practice, and this is to take place, usually we do this in the forms you need to know class. So check the calendar for that. But the form that you're going to need to make sure that the listing broker pays another broker is called a broker, the broker to broker agreement. And so you need to have that in place as well, but get with your broker and see how they want to do that. But this is what you utilize if you have the information from the listing agent that the seller has agreed to pay the buyer's agent's compensation. All right, moving on to the third-party financing addendum. We have some changes in that, and we've already talked about that. So this is talking about the third-party financing addendum to ensure the buyer is terminating appropriately. Paragraph 2A, buyer approval, has been changed to require both a notice of termination and a copy of written statement of the lender's determination, like in paragraph 2B. Property approval. The language in paragraph 2B is modified because the language related to notice of termination timing was different than other contract provisions and was causing a lot of confusion. So TREC took that into consideration and made it a lot clearer for us to see. Got that? So here's what that's going to look like. Sorry that I'm having to move this around. So here's what it says. Buyer approval. Box 1, this contract is subject to buyer obtaining buyer approval. If buyer cannot obtain buyer approval, buyer may terminate this contract within so many days, that's negotiable, after the effective date of this contract by giving seller, it's a little I, notice of termination, and a copy of a written statement from the lender setting forth the reason or reasons for lender's determination. If buyer terminates the contract under this provision, this contract will terminate and the earnest money will be refunded to the buyer. If the buyer does not terminate the contract under paragraph 2A, the contract shall no longer be subject to the buyer obtaining approval. Buyer approval will be deemed to have been obtained within one little I. The terms of the loans described above are available, and two little I's. Lender determines the buyer has satisfied all of the lender's requirements related to the buyer's assets, income, and credit history. So remember, this is buyer approval, not property approval. So don't get the two mixed up. Okay, so this is just the buyer's approval process of it. Okay, so we have to give them the notice of termination and a copy of the written statement from the lender setting forth the reason or reasons. It wasn't happening before. Agents were getting confused, sellers were getting confused, buyers were getting confused. So they tried to make this a lot clearer so that we all understood what is required in order to terminate. And this would be utilized after the option period. Remember that option period is totally different from buyer approval. Option period is a walkaway period for any reason whatsoever within the amount of time that has been negotiated. Buyer approval specifically talks about the loan. So make sure you're understanding the two separate on that. So requirements in paragraph 4. This is for the FHA and VA. So requirements in paragraph 4 is made singular and a conforming change is made to paragraph citation. So they're just changing a couple of words from requirements to one requirement. And the 3-day notice of the termination requirement in paragraph 2B does not apply to this paragraph. Okay. All right, so due to some concerns and confusions regarding our addendum for backup offer and the improper use of paragraph 11 for special provisions by license holders, this addendum for backup offers, backup contract has been modified to provide more clarity on the timing and payment of the earnest money and the option fee, by incorporating similar language from paragraph 5 of the contract and by addressing timing and payment of additional fees. So a lot of times this is the only reason agents would not want to use a backup addendum, because they were more confused about it than they ever thought and wanted to admit. So they just wouldn't utilize it, which is crazy. It's a form that is there, it's available, and a lot of times you are not doing your fiduciary to your buyer if they're not allowing, if you didn't know it and you weren't allowing it to be done. So let's take a quick look at it. It has changed tremendously. So this is what it looks like now. You will see a lot of blue on this particular form, which means this is everything that was added. So I know you're having a hard time reading it. So let's take a little closer look at it so you can see what it is. So it says the contract to which this addendum is attached, the backup contract, is binding upon execution by the parties, and the earnest money and the option fee must be paid as follows. Buyer shall deliver the earnest money and option fee as provided in paragraph 5 of the backup contract. And 2, buyer shall deliver earnest money of whatever amount and the additional option fee of whatever amount to the escrow agent at a specific time that's been negotiated after the amended effective date of the backup contract defined below. So B, If the last day to deliver the additional earnest money and the additional option fee falls on Saturday, Sunday, or legal holiday, the time to deliver the additional earnest money or additional option fee is applicable is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. Same verbiage that is in paragraph 5 of the contract. C, the amounts escrow agent receives under paragraph A2 of this addendum shall be applied first to the optional option fee and then to the additional earnest money. That also mimics the 1-to-4 contract. So D, buyer authorizes the escrow agent to release and deliver additional option fee to seller at any time without further notice, or to consent from buyer, and releases escrow agent from liability for delivery of the additional option fee to seller. The additional option fee will be credited to the sales price at closing. So just like any option fee, if we're not in a backup offer, say we had to extend it on an amendment, that money has to be given to the seller, and then it is credited back to the buyer. So here's the failure to timely deliver additional earnest money. If buyer fails to deliver the additional earnest money within the time required, seller may terminate this contract or exercise seller's remedy under paragraph 15, or both, by providing notice to buyer before buyer delivers the additional earnest money. So I hope you guys are seeing what they're doing. Very succinctly mimicking everything that is in the 1-to-4. And so they're almost like reiterating it. F talks about the failure to timely deliver the option fee. Again, failing to deliver earnest money, failing to deliver option fee could allow the seller to terminate and go to a different buyer. So let's read what F states. Failure to timely deliver additional option fee. If buyer fails to deliver any required additional option fee within the time required, buyer shall not have the unrestricted right to terminate this contract as provided in paragraph 5B of the contract. So make sure that you're doing your fiduciary with your buyers to make sure you're keeping them on track with following the dates that are required. And the rest of them have not changed at all. They've just been alphabetized. I usually say renumbered, but these are all alphabetized. So B became H, C became I, D became J. Now J has a changed effective date to capitalization. So make sure that you guys are utilizing this, and understand too that just like a regular contract that your buyer is in first place, if they terminate, option fee is never given back, only the earnest money. So if you're not comfortable with the backup offer, get with your broker and talk to them. Maybe do some role playing with it, because it is a great form to utilize, especially with the landscape that we're in today with some buyers. All right, moving along, a very new form that TREC wanted us to have, because they're starting to utilize a 1031 exchange. Now, if you don't understand what 1031 exchange is, get with your broker, make sure you're allowed to do that. Take some classes on it. We offer it here at MetroTex, so you can understand what the use of this addendum for Section 1031 exchange is. So let's read and see why TREC did this. So the committee, which is the broker lawyer committee, drafted a new addendum for Section 1031 exchange that allows the seller or buyer to disclose an intent to use the property subject to a 1031 exchange. And it includes a statement that the parties will reasonably cooperate with one another. Providing this as an addendum rather than in the contract allows the parties to use it when applicable without causing unnecessary confusion. A reference to the new addendum for Section 1031 exchange is also added to paragraph 22 of the contract, which lists all those notices. And so the reason they're wanting to do this also is because it does sometimes take a little longer for the transaction to occur with a 1031 exchange. And sometimes it actually has to move a little quicker, just depending on where they are in the whole process. So here's what that new form looks like. Again, make sure you understand what a 1031 exchange is and that your broker allows you to do it. We just wanted you to be aware of the new form that is out there. All right, there are some additional changes that are going to be taking place in 2025. You will see that this is going to be the earliest adoption for this one is going to be February 10th of 2025. And this is the information about brokerage services. So this is that form that we are supposed to be giving to the consumer on the first substantial conversation that we have with the consumer so that they understand that they have a right to representation and that everybody has a right to representation within a real estate transaction. So let's read and see what they are doing. So according to the amendments to the 531.20 and the form adopted by reference, the information about brokerage services IABS notice are made as a result of a recent industry changes surrounding broker compensation to clarify the consumer that any brokerage fees are not set by law and are negotiable. And you will see that we also have it in Spanish, so you understand it. So right now we just have the draft of it, and it is just adding that an owner's agent fees are not set by law and are fully negotiable. And that's what the lawsuits were all about. And so now the state is on board and they want to make sure that consumers understand that as well. All right, so moving on, there are two forms that are no longer going to be utilized that Texas Realtors did develop back in May. And so we wanted you to be aware of what those forms are. So the first one is that amendment to the representation agreement. If you remember when this came out and we were doing classes on it, we did mention that this was a grandfather form and it was going to be temporary. And what this was, it was to get all of those forms prior to June 24th and actually August. I even have forgotten what that drop dead date was for NAR. But anyway, so prior to that, we had to get all of our agreements brought up to compliance. And that's what this form did. So as of December 16th, 2024, this form is no longer out there in our systems to be utilized. So that one has gone away. So you will not see this one anymore. The other form, addendum regarding brokers' fees. I know I'm going to hear a lot of moans and groans about this and a lot of cheering. So we have both ways, both feelings on this one. So this is that addendum that we were letting the sellers make a decision whether or not they were going to pay a compensation when we removed it out of the MLS. Or if we didn't have that agreement, listing agents didn't have an agreement, then the buyer was still able to ask for the seller to pay the buyer's agent's compensation under D2B. This form has gone away now because TREC has now addressed that situation in paragraph 12. So no need for this form anymore. So I know a lot of people didn't like it. On the flip side, there were a lot of people who did like it. So just know that it has gone away. Now, just to keep everybody kind of up to date on these forms, these changes, there may be some other things coming along, okay? But again, what we've talked about today has mostly been from TREC, couple here with Texas Realtors. But because the industry is ever evolving, we will probably see some additional changes coming down the pike. So give each other grace while we're working through these changes. Paragraph 12 looks completely different. Not everybody's going to understand it. So let's just make sure we're working together, making sure that we're getting the consumers where they want to be. And most of the consumers are going to be our clients. So we need to make sure that we understand the new forms and that they are able to make the informed decisions that need to be made so that they can get to the closing table. So my name is Cindy Bass. I appreciate you spending time with me as we go through the new changes. Make sure you pay attention to Metro Texas website. get in those classes, the forms you need to know, anything regarding forms, so that you can get a better understanding of what is going on in your industry and your career, so that you can be successful and help your clients be successful in their real estate journey.